right, I beg your indulgence. We're just waiting for Ms. Hinson. Mr. Lee, while we're waiting for Ms. Hinson, how long do you think your last witness will be? How much time do you anticipate?
The gentleman is a character witness, so it'll probably be quite brief.
Yes, sir. If you're ready, Ms. Seibert, we're back on the record in case number 64719. I am so sorry, Mr. Lee, to have interrupted you in the middle of your examination. You may continue.
Thank you, sir. Mr. Tolley.
Yes.
Do you recall the last question I asked you?
Gosh, I can't. I mean, I think it had to do with kind of why did we make the decision to accept a deferred adjudication offer on reckless misapplication? I think something along those lines.
I think we were discussing whether there were any lesser included offenses, or if you had known what you know now about the state bar rules, was there an option besides accepting this plea?
No, there's just really not. There really wasn't. There isn't now. I mean, there's not other provisions of the penal code that we could accept. Again, the stated objective from the state was to set up an amount, a term of probation, the number of years that would allow us to be able to pay that money back. If we could have paid that money back, my understanding was the charges would have been dismissed. And so you're looking at anything over 2 years as a felony. So it was going to take him more than 2 years to pay this amount of money back. And so it just became much more an exercise first of trying to figure out how long it would take to pay this money back. And then it became an exercise of, are there other charges aside from misapplication that would work here? And there just isn't any that don't involve substantial collateral consequences.
But, well, gee. So,
I mean, I mean, obviously we could have gone to trial. I mean, there's not,
yes.
Clearly if there, I mean, hindsight's 2020, right? I mean, you might want to, but then it's just.
You risk imprisonment, right?
Of course.
But I believe what you're telling me is that Mr. Rios had the good fortune of having rich parents or winning the lottery or something. We might not be here today.
That's not a flippant comment at all. I mean, that's literally what it came down to, was the ability to, the more you can pay back, the less your exposure, vis-a-vis the type of felony you're looking at or misdemeanor is, and so on. And so that's exactly right. I mean, if he had the benefit of accessing funds like that, we wouldn't be in this position.
I'm sure you represented plenty of criminal defendants who are being prosecuted by the Travis County District Attorney, correct?
Yes.
And would you agree with me, in some instances, there seems to be a sense of anger or moral outrage or reprobation against the defendant, correct?
That there can be,
Yeah.
and yes.
Was there anything like that in this case?
Absolutely not. At no times, at no time, pardon me, I'm just trying to remember back when there was a pause, quote unquote, in our negotiations. It really centered on, you know, agreeing on a dollar amount that made sense, or agreeing on how much upfront we could try and pay back, things like that. It was never a pause to check the temperature or pulse of Mr. Capitan or Mr. Park. And again, they had a substantial bite at that apple. They swore and affirmed through verified pleadings in district court at the federal level, you know, in Corpus Christi and bankruptcy court, you know, what their concerns were. And so none of those were about not trusting Jerry like that, or thinking that he was a thief or stole money from borrowers or things like that. It was always about the ability to pay this money back to them. And so they didn't allege any of that. That debt was discharged in bankruptcy court. So that's why I can confidently say I just don't believe circumstantially, or nor did I ever receive any information directly that they were morally outraged or upset or anything of that nature.
Not the complaining witnesses, the prosecutors themselves, I'm asking.
I'm sorry, no, certainly not. And also another sort of indicia of that belief that I have on that is that at no time did they try and talk to people who were clients of Jerry's, or try and dig into other issues, or express concern about, well, I don't like this deal because I don't, you know, he's not a good person, or I'm outraged by this behavior. Nothing like that. No.
Did Jerry ever express anything like outrage that the Travis County District Attorney had picked up the sword for Park and Capitan?
I think it would be disingenuous to suggest that we weren't frustrated at the belief that this should be a civil matter, that we thought this was handled already. But outrage, no. A strong desire to make amends, to fix this, to accept responsibility for the part we learned from, and to move forward. But certainly not outrage, no.
Then finally, just in the course of representing Mr. Rios, or in the course of assisting as a factual witness in this case, is there anything you've learned or that you would like to share with this tribunal that you would believe be useful to them in evaluating whether to disbar or suspend Mr. Rios?
Gosh, I do believe some relevant factors to consider are that the people closest to this, the receiver, the trustee, the bankruptcy judge, the district judge, the assistant district attorney, everyone was unified in the agreement that these mistakes Jerry made, and his fiduciary responsibilities occurred before he was sworn in as a lawyer, and occurred with permission. You know, that was our assertion. We had a lot of documentation to support that. And so based on those, everyone wanted him to practice law. There was never a discussion about, well, I don't know if I'm comfortable with this, or I don't think that's a good idea. And I do think it also matters that, you know, the length of probation was solely negotiated and agreed upon based on the actual ability of how much we could pay monthly. And for Mr. Rios to be honest and transparent about his abilities to pay that money back and face more probation time, to me is a sign of somebody who's honest, you know, and who's transparent and has accepted responsibility. Because a lot of people commonsensically, and I have experience with this, you know, with my clients, will say, well, I could do it in 5 years. I can't be on probation for that long. I can't have somebody telling me what to do for that long. And Jerry didn't have any of those concerns. It was always about, well, if I'm going to do this agreement and stick to my word, I need to be able to pay it back. And so it's going to have to be a longer amount of time. And so I think those are very relevant factors in determining how much he's accepted responsibility and why he should not, you know, face the ultimate penalty here.
One last quick thing from you. I believe I pointed out to you, and you've now read, that the early termination of probation would not shorten the sentence. So if he won the lottery this Saturday, paying it off and getting an early termination would not change the outcome of this hearing, correct?
I'm sure that is correct. I understand that. I think I mentioned that because I think when on its face, when somebody looks at something and says, well, that's 10 years, you must have done something terrible. So, well, no, there's actually we're not disputing that what happened is illegal and that we've accepted responsibility for that. What I'm saying, though, is that, the amount of years is not indicative of the particular conduct that was admitted to. It's a malum prohibitum conduct, and so we accept responsibility for that.
So from what you're saying, I would take it that when one thinks of moral turpitude, you generally think of things that are evil in and of themselves, even if not illegal. Here, this one is moral turpitude because the bar rules say so, not because of the conduct involved.
Yes.
Okay. And I would simply, between you and me, in case we don't speak again, should Jerry win the lottery and wish to terminate this early, you are aware that there is precedent before this body of the means by which the sentence can be shortened, which could result in his return to practice soon, correct?
Yes, I am aware of that, and that's why I mentioned that the way the deferred adjudication and community supervision terms are set up, that it's absolutely determinative of his ability to pay that money back faster. That's all that's relevant here.
Thank you. I'll pass the witness.
Mr. Berry?
I'm sorry, I had to unmute. I have no questions. Thank you.
Members of the board, questions for the witness?
I've got a question, if I could, please. Mr. Tolan, Michael Gross. When you and your client met with the prosecutors, like you talked about, did the prosecutors tell you they did not believe it was intentional or knowing conduct?
Yes.
Did you explore the possibility of pretrial diversion with them so none of this would have happened?
There was not, yes, we did. There was not pretrial diversion. There was not an option for pretrial diversion that the state felt comfortable with. And so that was not something they were willing to do. And I think a lot of it was just the ability to still maintain leverage over someone who owes that amount of money was the principal concern there.
And then the last thing, just touching a little bit on what you said about the discussions outside the record at the plea and sentencing. Am I understanding this correctly that that Mr. Rios, when he pled and was sentenced, that it was the judge's understanding and the prosecutor's understanding and yours and Mr. Rios's from y'all's discussions that Mr. Rios would be able to continue practicing law after this deferred plea?
Yes, sir. I can't stress that enough, that everyone knew that it was determinative that if he couldn't practice law, it was going to be extremely difficult to pay this money back, and no one had any concerns about the moral fitness of him to practice law. All of these questions were always centered on, how much can you pay? How fast can you pay it?
And so on that, have you filed anything or contemplated filing anything to overturn that plea for it being involuntary?
I have not been asked to do that. So no, sir, I can't say that we've done any inquiry into that.
When you and Mr. Rios discussed this and he realized he was going to lose his license, did he discuss the possibility with you of attacking this verdict, this judgment then as being the product of an involuntary plea?
No.
Okay, thanks. Those are all the questions I had. Thank you, Mr. Gonzalez.
I have a few follow-up questions because here's where I'm getting confused, Mr. Toland. And I'll just tell you, so we have to look at some of the factors related to the standard of the maintenance of the respect for the profession and the seriousness and circumstances. And I just need some clarification on if the mistakes that we're talking about are mistakes as a borrower or the mistakes as an employee, because I know that there's a difference. If someone had a high interest credit card debt, I just can't see someone filing a criminal charge. But I know that if someone thinks this is embezzlement type conduct, then it's a different matter. And so can you help articulate if there's this bankruptcy and this discharge, why is there any restitution owed unless that there's an allegation that this is an embezzlement type offense?
Well, it's a great question. So some of the conduct alleged was between Mr. Capitan and Mr. Park. And so some of the issues become, even though we had some documentation that we believe supported the notion, not just a notion, but clearly the argument that Mr. Park had given Jerry, Mr. Rios, permission. So as an employee, like he had permission so that it wasn't analogous to embezzlement. We weren't sure. Mr. Capitan, I don't think, held that position. And so I think what happened is Mr. Park and Mr. Rios did most of the yeoman's effort here. There's also the issue of being a borrower from them, Jerry himself. And that's where the bulk of this money of restitution is owed back. And that's why we went from 600,000 down to about 188,000. And so a lot of that was for law school. He's in law school this whole time and working and traveling for them. And so
how's a
that helps.
borrower fiduciary?
Well, I think what they're saying, sir, is that he's taking money. So when borrowers are giving money, some of that money's mixed and commingled. And so for us to go back, we would have had to have parsed that money out, So some of that's commingled. Some of the money that Capro gave to Mr. Rios is mixed in with borrowers' money. And so the belief of Mr. Rios at the time is that Mr. Park has given permission for that. We'll just pay yourself out of that. And that's clearly misapplying your fiduciary responsibilities.
Well, but wouldn't there have been a restitution hearing, or you could have had a restitution hearing to say this is the amount of debt that was discharged in bankruptcy and then shouldn't be required to be repaid?
So we spent a lot of time when we met we met with the Travis County investigator and with Mr. Henneke at the time. That's essentially what we did in that 4-hour meeting, is kind of parse through what we thought we could agree on for the restitution.
So does this restitution, is the amount, I guess that's the fundamental question.
Yes.
I see a case very differently than if someone is in debt because they had a high interest loan, whether they're an attorney or whether they're a member of the public, versus somebody that was in a nature of their employment, paid themselves through funds they shouldn't. So is the bulk of that $150,000 payments to himself that weren't discharged in bankruptcy because they were not a loan?
Well, I don't know. I think the issue was that some of those loans were not quantifiable in bankruptcy court. But we asserted, and I think Mr. Henneke felt comfortable with that based on his conversations with Mr. Park and Mr. Capitan, that those were analogous to loans. And so that he needed to pay those guys back for that. And so.
Thank you, Mr. Dillon.
Okay.
Are there any further questions from the board?
Well, if I may, Mr. Gonzalez, I think, and I can understand sort of the troubling concern there. And I think a large part of that too was at no time were any of the borrowers. In fact, we had several borrowers that were going to be witnesses for us. So, I mean, at no time was it alleged, and at no time did anyone contemplate charging him with embezzlement, or at no time was there firm documentation showing that, hey, you stole this from a borrower without Ron knowing about it, anything like that. It was strictly misapplying that. And so I think our concern was that Mr. Park was going to come say, when faced by Mr. Capitan, like, I don't know if I gave permission for that. I don't know. We felt like we had documentation to show that. And so I think that's why everyone agreed that it was reckless, and Mr. Park was comfortable with that. I don't know if that helps answer your concern, but.
Mr. Gonzalez, may I ask a few questions? Maybe I can clear this up, or maybe I'll just add to the confusion.
Please redirect.
In talking with Jerry, I sort of got the impression that there was two main categories of conduct, and they weren't necessarily both cognizable in the criminal process. One is, my understanding was that Jerry had some concern that if he accepted, say, $1,200 from a borrower, remitted 1,000 of it because he was entitled to keep, a percentage. But that was documented. It was a verbal instruction with Mr. Park, and it was later documented by a spreadsheet showing where the money went. that
Mhm.
absent the principal's specific consent to handle the funds that way, that can be considered misapplication.
It is, because the borrower is the person that it's a substantial risk of loss to that borrower. Like, the borrower doesn't give permission for that. So Mr. Park can say that, and Jerry, as an employee of Mr. Park, can think that's okay, but Jerry still has a fiduciary responsibility there. And so that's where it's reckless. You can't do that.
And I believe a second concern was that there may have been instances where Jerry was entitled by anyone's accounting to retain $200, but Mr. Park gave him permission to take an advance to keep 400 instead of only the two. Am I correct about that?
That's 100% correct. A large part of his ability to pay for law school, pay where he was living, and pay tuition, stuff like that was based on, he'd known these gentlemen before growing up in Corpus, and so the goal was to go back to Corpus Christi, practice real estate law, and work with those guys, and have this investment continue to pay off. So that's correct. They were
Right.
lending him money.
And absent the specific express consent of the principal, the lender, Dr. Capitan, that could have been a problem.
Yes, it
And
is.
then my appreciation was there was a third issue, which was that I don't know if this was going to come up in the criminal trial. You could tell me, but that Jerry, as the mortgage broker and as a borrower, potentially had a conflict of interest, and he could have been accused of giving a loan to an inadequately securitized borrower, namely himself. And even if that wasn't part of the criminal case, he seemed to be expressing he was always willing to pay back the money he owed, even if it was just charged in bankruptcy. That the discharge in bankruptcy was because of the excessive amount they wanted for him, and that my belief was they were trying to attribute other losses to him. You shouldn't have let us lend to this guy, so you should pay it back. And so he's never, the willingness to pay what he believed he owed also drove this, even if it wasn't part of the criminal process or or if it was in law discharged by bankruptcy. Now, am I wrong about that?
No, you're not. I mean, these are gentlemen that he grew up with and looked up to and wanted to do a good job for, and that's going to be part of his ability to practice law and do what he wanted to do in San Antonio, in Corpus Christi and things like that. So no, that's not wrong at all.
So the way I would present it is that Pitt, given the opportunity to continue practicing law, to pay back money he believed he owed, to avoid a finding of guilt for misapplication, reckless misapplication, he was willing to do this. And he, again, has offered no recrimination against anyone. He hadn't said the district attorney's office is acting as a private collection agent. How dare they? He hadn't accused you of lack of zeal. And as far as I know, he hadn't lashed out against Ron Park or Dr. Capitan. Am I incorrect in that?
Well, you are not incorrect in that. And also a condition of, our term of probation is that we're, not to communicate with them. And so we abide by that. I mean, we're not.
Now, Mr. Gross asked you about perhaps withdrawing the plea as involuntary. Would you agree with, am I correct that if you did that, that would then basically put him in the position of going to trial on the merits? If he's
Yeah, I mean, assuming that writ was granted and stuff, you go back in harm's way, correct?
But, in that line, I've discussed with you this body's holding in the Malhotra case, which indicates that an amended judgment that shortened the term might result in a shortening of the period of suspension, but that's really only going to occur if the money gets right, correct?
It would only occur, yes. I mean, I guess it's in theory possible that they might decide that they are not going to, that they're okay with something less than what was agreed upon. But other than that, that's correct.
Okay, thank you. I'll pass the witness.
Any recross, Mr. Berry?
No, thank you.
Any further questions from members of the board? Mr. Tolan, thank you for being here. You may be excused.
Thank you,
Mr.
Chairman Gonzalez.
Tolan.
Thank you.
Mr. Lee, you may call your next witness.
The final witness is Mr. Chris Mojica.
Hi, sir. Can you hear us?
Yes, sir, I can.
Great. Would you please raise your right hand and be sworn? Do you solemnly swear or affirm under penalty of perjury that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Lee, you may proceed.
Hi, Mr. Mejica. Sorry to keep you waiting.
No worries.
As a lawyer, I grossly underestimated the time this would take. Would you state your name for the record, sir?
My name is Christopher Mujica.
You're a licensed Texas attorney.
Yes, sir, I am.
Tell us a little bit about yourself, such as where are you from?
I'm from Austin, born and raised. Went to law school, went to undergrad at UT, and then went to law school at the University of Notre Dame. I've been practicing with my law firm since 2000, so for almost 21 years.
And
I'm
what
a commercial
area
litigator and a partner at Jackson Walker.
you're employed? I'm sorry, you're employed as a partner at Jackson Walker.
Correct.
What's the area of practice that you're engaged in?
Commercial litigation, primarily fiduciary litigation, and then some real estate litigation, but general commercial lit.
Okay. Are you active in the voluntary bar, like for the Austin bar or the state bar voluntary activities?
I have been, and I've served in a number of diversity initiatives. I was the co-chair for the Texas Minority Council program for a couple of years, as well as a member of that committee. I've been involved with the Leadership Council of Legal Diversity on the executive board and as a co-chair for their alumni symposium. And then I've tried to help with various pipeline programs at some of the area law schools in Texas, as well as through the state bar.
Are you active in any voluntary service for the community at large, the non-legal community?
Yes, sir. I've been on the board for the Austin Sunshine Camps and the Young Men's Business League off and on for various years. I'm still on their foundation board. I was also on the executive board for Boy Scouts of America Capital Area Council for a number of years. And then I serve as an assistant scoutmaster and chaplain for the Boy Scouts for my son's troop for about the last 8 years.
And just for, you recall, we were set in January and I had a medical incident, but there was a possibility you wouldn't be available to participate because of a family activity. Is that correct?
That's right. My son's Eagle project was at the end of January, and because of the confluence of events, we were able to get this reset. But yeah, he as a typical teenager, put it down to the wire, and he had received an extension from BSA. But I want to say he had to have everything completed, including a Scoutmaster conference, by February 6th. And I think the last hearing date was the very end of January. So he was cutting it close.
And you would have been, it would have been required to help him had that.
Absolutely.
Yeah. Are you licensed by any other states or by any other jurisdictions or by any other governmental agencies that require admission to appear before them?
Yes, sir. Obviously, I'm licensed here in the state of Texas, and I'm licensed in the northern, southern, western, and eastern district of Texas. I'm licensed in the Fifth Circuit, the United States Supreme Court, and then I've been admitted pro hoc to practice on particular cases in California, Virginia, Mississippi, and Illinois.
With those presumably then you have no attorney discipline on your record?
Correct.
How did you become acquainted with Jerry Rios?
Jerry and I were opposing counsel on a real estate litigation matter about 10 or 11 years ago. I want to say it was about 2010. And I don't even remember exactly the posture. I believe my clients might have been defendants, but that's how I first became familiar with them working in that case opposite each other.
Anything notable about that case or his behavior in the case?
I found him to be a reputable attorney in the case. The kind of a lawyer that if I were to send an email saying, can we agree to move this, I wouldn't have to get a Rule 11 from, or I could pick up the phone and make a phone call and have an agreement with him, and I could take him at his word. I very much enjoyed working with him. I think I prevailed in that case, and that's not the reason I enjoyed working with him, but I did enjoy working with him, and I think all of us as practitioners can appreciate that there are times we don't necessarily enjoy working with certain opposing counsel.
You mean the sort of lawyers can't do anything unless they're angry?
That's right. And they like to play games, serve stuff at 6 o'clock on Fridays, or harass you on the weekends, or send bombastic emails. Jerry was a pleasure to work with in what turned out to be a nasty piece of litigation, at least for a short while.
Have you had any other professional dealings with Mr. Rios since the conclusion of that case?
Yes, sir. Jerry, a couple of years later, contacted me related to a matter he was handling. He was lead counsel in Travis County, and they'd received an adverse judgment against the client. And he asked me if I could take a look at it, collaborate with him, counsel the clients on it, and ultimately I did. I became his co-counsel on that matter. We first tried to get a rehearing on the matter, and then when we couldn't, I think we filed a motion for new trial and ultimately took the thing up on appeal. We were able to get it resolved on appeal, but we worked as co-counsel in that case, continued to serve that client on other matters together and separately. And at one point, he and I were opposing counsel on a different matter. It was actually a family matter. I was representing my grandmother on an eviction, and Jerry was representing the owners of the property, or the reputed owners of the property in that dispute.
And the matters you co-counseled with him, did that change your appreciation of his either skill or temperament as a lawyer?
I don't know that it changed. I think it reaffirmed my beliefs. I mean, for example, that first matter, he came to me quite humble and said, we lost this matter. There's an adverse judgment against my client. It's about to go final. Can you take a look at this? And he wanted a real assessment of what went wrong and how we could fix it. And then when we sat down with the clients, he invited criticism. And, unfortunately for Jerry, it was just a really bad set of circumstances that led to that adverse judgment, including, I think, a misapplication and misinterpretation of the law by the judge, which is why we ended up filing the motion for new trial and attacking everything on appeal.
And then in the last matter where you represented, you say your grandmother?
Yes, sir.
Did Jerry comport himself appropriately?
He did, and at that point, Jerry and I had become friends, and I think that he was reticent to proceed, but he understood that he needed to be a zealous advocate for his client, and he handled the matter, I think, with the grace and dignity you would want on any matter, especially one for me that's as personal as that.
Do you recall when did you learn that Jerry had been charged with a crime, or if you didn't, when did you learn that he had agreed to be on deferred adjudication probation for a penal code violation?
I'm not entirely certain when I learned about the criminal nature of the issues before the panel today. I know that Jerry and I spoke, I'll say 5 to 7 years ago, maybe in that time frame, about issues going on in Corpus, about the fact that there were some allegations, breach of fiduciary duty, some potential litigation. And I don't know if I knew that there were criminal charges then, or if that's something that I only recently found out in connection with this proceeding. But I can tell you now with certainty that I 4 or 6 months ago or so, when you reached out to me, and when I knew with any kind of definity that there had been some criminal charges and an outcome from that.
Did Jerry seek your advice or counsel about the civil suit in Nueces County against him?
He did. At one point, he was looking at retaining me and my firm to defend that matter.
But did you ever enter an appearance in the case?
No, sir.
Did you have any involvement in his decision to declare bankruptcy in the face of that litigation?
I did not.
Okay. And did you have anything to do with the bankruptcy case itself?
No, sir.
Okay. Well, what's your when you did learn that Jerry had accepted a plea for reckless misapplication of fiduciary property, what was your reaction or your internal thought process when you heard that?
Well, I was disappointed for Jerry. As I said, I've come to be fond of him. I think he's a nice guy. I think he's a hard worker. And my understanding of the transactions that went on in Corpus or wherever it happened was that it was a situation in his pre-law life where he was involved with a hard money lender, And I know that those transactions can go awry a lot. From my own professional dealings with hard money lenders, I've represented them. I've been adverse to them. They've been, collateral parties in litigation I've handled, and I appreciate the fact that those loans do go into default, and sometimes those loans are given to distressed borrowers, and circumstances happened, and so I just, there was sort of a personal level of sympathy. Just kind of, felt bad for the guy. That's what it ultimately came down to.
Have you ever represented anybody who was a mortgage broker assisting hard money lenders who were then later had issues with their loans?
I've represented hard money lenders and some of the brokers and affiliates within that structure. They may not be directly employed, they may be independent contractors, but yes, I have.
Okay. Did you ask questions of Mr. Rios? I mean, since you'd become fond of him and then you found that he was entering a criminal plea, did you ask questions of him to double check your impressions of him or your opinions of him?
I didn't feel it was necessary, and I won't even say that I felt like it wasn't my place to do that, but I'd already formed an opinion of Jerry and his character, and he was quite contrite when he mentioned these issues to me. It was not a, oh my gosh, this is all BS or anything else. He kind of came hat in hand, especially when he came for that consultation, just to talk about how these issues had come up and how he was trying to address them and get in front of them and make things right, whatever that meant.
I've explained to you that in this hearing, the state bar is asking, as they always ask, for disbarment. And Mr. Rios is pleading that he be suspended instead of disbarred so that he may return to the practice when he completes his criminal probation. You're aware of that, right?
Yes, sir, I am.
Knowing what you know now and thinking about it, do you have any concern about Jerry's qualifications, his moral standing to return to the practice of law when it's available to him?
I do not. I've referred matters to Jerry in the past, and if he were still a licensed practicing attorney, I would refer matters to him in the future.
Are you concerned about your reputation, or referring someone to a lawyer who's had problems such as his?
I'm not, and in fairness, I will tell you that I disclose that kind of information to clients when I do make a referral. I would say, this is an attorney that was suspended but is licensed to practice again, if that were the instance.
Okay. And then finally, I really appreciate the time you've taken waiting for this, and I've tried to kind of speed it up. So let me just ask you a broad question. Is there any comment that you can share with this tribunal that you believe would be useful to them in evaluating Mr. Rios' future as a lawyer?
Well, as I've indicated, throughout the 10 or 12 years I've known Jerry, I found him to be quite a humble guy. I found him to be a hardworking lawyer. I found him to be quite a zealous advocate for his clients, even in situations where I felt like he had quite an uphill battle to wage on behalf of those clients. But what I found most impressive early on when we started working as co-counsel was how much he was humble and would go to his clients and say, look, I've got this lawyer. This is Chris Mojica with Jackson Walker. I respect him a lot. And Chris, tell me what we did wrong. I mean, he invited that criticism in front of his clients. It wasn't a, hey, can you help me fix this? Hey, can you help me cover this up? Or hey, can you somehow, conceal from the client mistakes that were made? Instead, it was, he invited the harshest criticism. And in that instance, fortunately, there wasn't any harsh criticism to be had. It was just a bad set of circumstances that I think led to that adverse judgment.
Well, I'll pass the witness. Thank you for your time, sir.
Yes, sir.
Mr. Berry?
I have no questions, Mr. Chairman.
Members of the board, any questions for Mr. Mojica? Hearing none. Mr. Mojica, thank you so much for being with us, and sorry to keep you waiting.
Thank you, Mr. Chair.
Mr. Lee, your next witness.
I have no further witness. Responding Riss.
And Commission, any rebuttal?
Sorry, no, we have no rebuttal, Mr. Gonzalez. Thank you.
You may rest and close.
Yes. Okay.
And I would briefly ask, So mindful of the Asazi factors is certainly what we're looking for. If you could help direct us either along those lines as to the facts that we've heard, that would be helpful in our deliberations. You may proceed.
Okay, yeah, and I think part of the factors, and some are not obviously relevant here. I think the severity of the crime and the done to, or potential damage actually, to some of the clients at the time. He's paid approximately total of the 185 now, approximately 60,000 of what was owed. He's still a long way to go on that. I'm a little concerned. Although he says he takes responsibility, there's been some effort to classify the misapplication as a loan, or and somehow tied into that, or as a misunderstanding with Ron Parks on what he could take out. So how much that plays into his acceptance of his responsibility in this matter, I think is for the board to consider. Again, the prior discipline is another factor the board considers. So, that's just, a lot of the factors do not apply in this case, obviously. And then some of them, like the credibility, Mr. Rios's credibility is up for the board's determination and not for mine. Efforts at rehabilitation, filing bankruptcy to get out of a judgment, I think says, and it's not particularly acceptance of what, has occurred. So at that, I would, leave it to the board's decision as to the appropriate discipline in this case. Thank you.
Mr. Lee.
May it please this tribunal. It's a difficult case, or at least it was to me, because the fact that Mr. Rios's conduct occurred when he wasn't a lawyer, I thought was instructive and important. But as you've heard, Mr. Rios is a humble person. He wants to accept responsibility, and I think he feels a moral obligation to repay those debts. And so we've made the election not to try to, make new law and assert that since that conduct occurred outside the practice, that the fact that he's on probation now could be ignored. I think there are good arguments either way, but I believe the process of the decision on that was that it might be contrary with accepting responsibility to make such an assertion. And Mr. Rios wants to return to the practice of law, unwilling to risk disbarment by making a novel plea. And furthermore, he did what he did. He knows the conduct he engaged in. He's admitted everything. Yes, he was sued. And when faced with an insurmountable debt, he did what he has a legal right to do. He took bankruptcy. And when he took bankruptcy, any creditors had the opportunity to come forward and try to either lift the stay, exempt that debt from the stay, assert that he engaged in fraudulent behavior, and so it was a non-dischargeable debt, any number of things. None of that occurred. And then Mr. Rios gets confronted with the criminal accusations, and as you heard, he voluntarily cooperated with the Lakeway Police Department. He was unrepresented. He represented himself pro se. He kind of took the position that the truth is the truth. I have nothing but the truth to tell, so that's what I'm going to do. And then when he found that did not lead to his exoneration and he was charged, he hired reputable and qualified defense counsel who analyzed the case and looked at all possible options. And they both together came to the conclusion that there was conduct there. He was acting as a fiduciary, even though not as a lawyer fiduciary, and that under the reckless standard and the risk of loss, not actual loss even, he he had some exposure. He had some jeopardy for conviction. And above and beyond that, it came down to money. And so he was willing, as Mr. Toland said, to be on probation for quite a long period of time in order to discharge what arguably is merely a moral obligation to repay funds that he borrowed. And you heard he's raised no complaint. He hasn't complained about Mr. Toland for not looking into this more carefully. He's come to conclude that even if Mr. Toland had told him, I think this is going to get you in trouble with the bar, he was prepared to go forward. He's not acting from regret or hindsight. He's not recriminating against anyone. He said not a single unkind word about Ron Park or Dr. Capitan or the Travis County District Attorney's Office as a unit or any particular individual. And he is, as he displayed on his own, what Mr. Mahica described, a certain humility and a willingness to accept responsibility. So given all that, when you consider the factors to be taken into account, I don't believe there's been any evidence that there was profit to him or loss to another other than an unpaid loan. There certainly was no indication of intentional engaging in conduct he knew to be improper, but he took his chance anyway. There's no evidence of having been uncooperative with the state bar in this process, been uncooperative with the criminal authorities in that process. He's a perfect candidate to be placed on probation. And it's a very sympathizing situation when it comes down to it's all about money. You know, I have consulted with Mr. Toland that the one exception to early termination of probation that we found in the Maholtra case is that if the judge were to enter an amended judgment, changing the sentence, if Mr. Rios is on probation, then his suspension could be shortened. But even that's contingent upon raising money, and his ability to raise that money not practicing law is questionable. So I guess that's what I'm pleading is please place him on probation, or in the alternative, if because of his humility and his unwillingness to appear to be being defiant or seeking some sort of exception based upon the fact that he wasn't a lawyer when he was convicted, that he'd be given credit for that. And to the extent that if the board feels in any regard that I was not bold enough in asserting that position, and for fear of distracting from really the essence of the man he is, if that is an exception, if the fact that the conduct occurred as a non-lawyer and that takes him outside of the compulsory discipline, then that of course would be a wonderful outcome, but not one I'm necessarily expecting. So I put that before the board. I believe the case has been laid out. You've heard everything. You've had the opportunity to ask the people with relevant knowledge, and there's simply, I can't think of any good reason to disbar Jerry Rios. And with that, I close, and I thank you for your indulgence in hearing the evidence.
Thank you, Mr. Lee. Mr. Barry, do you have a rebuttal closing argument? Is it your burden?
No, I don't. Thank you.
Thank you, counsel. We'll now take this matter under advisement. It is 12:05. I'd like to go off the record. And Ms. Truitt, can we just have the board alone convene?